me start the recording. Okay. Well, welcome everybody, and thanks for your patience. And thanks for joining us today. I'm Sue Osthoff. I'm with the National Clearinghouse for the Defense of Battered Women, and we're here in Philadelphia. And I am your host for today's webinar. And I just want to go over a few logistics. So we've been trying to figure this stuff out as we've had people sign in. But if you're disconnected from the webinar, just go back to the original email that you got early this morning and click on the link again. So just re-enter to log back in. And if you have any problems getting back on, call iLink support 8, and their number is 800-799-4510. Dot has already put that in the chat box there, but if you just call, so those of you who are having trouble, it's 800-799-4510. So I think most of you know about the chat box, which is in the lower left-hand corner. So if you just bring your cursor over there and click in there, and then you can type. So why don't we all try it out? If you could write in where you are participating from today, and if there is more than one of you at your site, if you could let us know that, that would be really helpful. So just click in the box, type, and then hit enter, and that should bring it up. They've got people. You can see where people are calling from. Great. Really helpful. Greetings, greetings. This is really helpful. Thank you. Thank you very much. That's really helpful. And if there's if there is more than one of you at your site, please let us know. That's really helpful. As you probably figured out, all the participants are muted, so please use this chat feature for any of your questions. Or if you have any problems or any comments, put it there. And I'll be collecting the questions during the webinar, and time allowing, which there should be, we will pose as many as we can at the end of Cindine's presentation. So I'll be collecting them, and I'll acknowledge them when I see them so that you'll know that I got your question. Again, any technical problems come up, call iLink, and Dot will also try to help you. Thanks, Dot Goldberger. She's our assistant today from our office, and if you need to reach her, go either through the chat box or through her email, which is dot@ncdbw.org. We are recording today's webinar, and you'll be able to access this on our website, which is ncdbw.org, in about a week, and we'll put that in there as well in the chat box. We've also posted today's PowerPoint, and that's one that you can save and or print, and that's on Google Drive. The link was in our reminder note that you got this morning, and we'll post it again here. Thanks, Dot. And if you signed into iLink, you just don't need that right now. And then also, I will send an email shortly after the completion of the webinar. And it just has a brief statement of confirmation of your attendance. It has a link to our posted recordings and a very brief survey. This little evaluation is something that will pop up at the end of the webinar, and then also it will come in your confirmation email. It's just really helpful to us if you could spend really 2 minutes filling it out. It's great for our speakers, but it's also great for us to plan future webinars. So we really would appreciate it if you would do that. Also, to help our speaker, Cindine, and for all of us to know, let's see if I can get these polling questions up here. So we'd like to know, are you seeing them, Cindine? Are you seeing them on your screen?
I am seeing them,
okay,
yes.
That's great. So what we'd like you to do is let us know who you are, and also whether or not you've testified behalf or participated as an expert. And for those of you who are participating in iLink, if you could literally click your answer right on the little dot next to what it says. So if you're a community-based advocate, just go ahead and click that little dot there. That's really helpful. And then if you answer other, if you could click that dot, and then you could go right ahead and put in the chat box how you would describe your profession. And then we ask if you've ever participated as an expert witness in a case involving domestic violence, sexual assault, or other types of trauma. Are you an OVW grantee, and if so, what kind? I'm going to share the results of this. Cindine, are you able to see the results?
No, oh, yep,
The
now I am.
percentages?
Yep.
Okay. So you can see that the vast majority, 51%, if you put community-based advocates together with coalition staff and other national TA providers, are advocates. And we also have clinicians, some researchers, and other. And people are putting in what the professions are over into the chat box. So thank you very much. And that's helpful, too, to see that 26% have participated as an expert witness. 26 have not, and there's a number who are interested in doing so in the future. Okay, thank you very much. So let's move on now. That's really helpful information. Dot, if you can jot that down if you're able to, because we had trouble actually capturing this before while I go forward. So that'd be helpful if you can. Okay, and Dot, just do as much as you can, all right? For those of you who just joined, I'm Sue Ostoff with the National Clearinghouse for the Defense of Battered Women, and I want to extend a warm welcome to all of you. Thanks a lot for joining us in this webinar, which is the 7th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you've missed any of the past webinars in this series, including 2 other ones by Didnt Do It, our speaker today, recordings of these webinars are on our website. And Dot, if you could put up that information, that would be helpful. I also want to thank the Office on Violence Against Women for the support of this project on expert witnesses. It's been really great for those of us who have been working on this project to have a chance to delve more deeply into the topic and to work with really a great bunch of people from around the country, some of whom are on this webinar today. It's just been really terrific. Again, you've noticed that the participants are muted. As I mentioned earlier, we'll be collecting questions during the presentation, and time allowing, I'll ask as many as I can to Didnt at the end of her presentation. So as you probably know, today's webinar is called When Domestic Violence and Sexual Assault Advocates Provide Expert Testimony on Behalf of the Defense. And this is part 1 of a 2-part series. And our presenter today is Didnt Do It, as I've said a number of times, and it really is my pleasure to introduce her today, and it's certainly my pleasure to get to work with her. Many of you who have listened to other ones, other of our webinars, know Didnt is our legal coordinator here at the National Clearinghouse for the Defense of Battered Women. And we here at the National Clearinghouse are really fortunate to have known Didnt for a very long time. When she was in law school, she was actually an intern with us, so we have known her for a while. And then after she graduated from law school, she became a public defender here in Philadelphia, where she represented indigent people facing felony and misdemeanor charges. And interestingly, during her final year as a public defender, Didnt had a rather unique gig. She actually practiced exclusively in family court as a public defender, providing criminal defense to people accused of crimes involving the violation of a civil protection order. So she came to us with some really excellent and unique experience. In 2008, Didnt rejoined us at the National Clearinghouse, and she came on as our legal coordinator. And in addition to coordinating our little wonderful legal team, she also provides direct technical assistance to defense teams, and she does a lot of research, and she's been developing a lot of resource materials. She also conducts numerous training programs. She's also the lead staff of our Expert Witness Project, which, as I mentioned earlier, is funded by the Office of Violence Against Women. And in this capacity, Didnt's had an opportunity to attend a lot of trainings around the country that have been done by state domestic violence coalition and national organizations about how to be an expert and how to present expert testimony. She's been interviewing numerous trainers and expert witnesses themselves, and she's really been working hard developing resources designed to increase both the availability and the effectiveness of expert testimony for victims of ongoing battering. She's really learned tons from the training she's attended, so thank those of you who are on this, who are some of the presenters at some of those trainings, the readings that she's done, and particularly from the people she's had an opportunity to speak with who have generously shared information with her. So we really appreciate that. And our project partners in this project have been the Iowa Coalition Against Domestic Violence, so extra shout out to Lori Shipper and Kirsten Faisal from the Iowa Coalition. So before handing it over to Cindine, just a reminder, if you're having any trouble connecting or other tech problems, you can call iLink support at 800-799-4510. And then you can also put your questions into the chat box. So just remember, during Cindine's presentation, if you have questions for her, please put them into the chat box. I will collect those. We really want to hear your questions, and we're planning to leave about 15 minutes for questions. So thank you. And Cindine, thank you so much for all your great work and for your willingness to share it with all of us today. And so now, without further ado, finally, I get to turn it over to Cindine. Thank you.
Thank you from down the hallway, Sue O. Hi, everybody. I'm glad to be here talking with you today about some of the things that I've learned throughout this project and through my work here at the National Clearinghouse. As you might remember from the program description, we've designed today's presentation to mostly focus on domestic violence and sexual assault advocates who get called to testify on behalf of the defense. So although we have a lot of practitioners on this call, you're going to notice that the lens that we're using is going to be maybe for people who have that advocate role as a profession. And the reason that we're doing this is because this project has taught us a lot. And one of the things we've learned is that community-based advocates who have experience testifying as experts have often only done so on behalf of the prosecution because that's what they're asked to do. And so that when the defense attorney calls, there might be some questions that come up about how that job might look the same and how it might look different than testifying on behalf of the prosecution. So today we're going to focus exclusively on defense testimony. Okay? So we have other webinars on other topics, but today we're really going to hone in on the things that are unique to testifying on behalf of a battered defendant. So as you probably know, and as Sue talked about a little bit, the National Clearinghouse for the Defense of Battered Women works with victims of ongoing battering who have been charged with crimes. And in this capacity, we get to work with defense attorneys, we get to work with survivors, and we get to work with expert witnesses. So we're hoping that that perspective is helpful to you in sharing what we see. And just to give you a little roadmap about the kind of cases that we tend to work on the most, you know, there's a lot of self-defense cases. I think that's what most people think of. We see duress and coercion cases where a defendant gets forced by another participant into participating in a crime. We see parental kidnapping cases, failure to protect cases, cases where somebody made up the charges completely, and then of course we see the famous perjury cases where battered women are accused of making stuff up. We're going to be getting back to these, okay? I just wanted to kind of give you a frame to look at while we're moving forward. Okay, so I've got one of those battered women cases. This is what we hear a lot when we pick up the phone, you know, when we're hearing from an attorney, and I'm sure for the people on the call who have been asked to testify, this is what you hear too. I've got one of those battered women cases. So perhaps that means if I can prove she's battered, maybe I'll win, right? Well, we'll be getting back to that. So this phrase is often where the conversation starts. When defense attorneys know that they might be representing somebody who's experienced ongoing battering, they know they need to get an expert. But that's not the only question, okay? Defense attorneys also have to figure out not only is his or her client battered, but are those experiences of abuse going to be legally relevant to the case? That is, are they going to be admissible and have something to do with proving or disproving a part of the case? The lawyer is also going to have to think about how those experiences of abuse are going to be helpful. Because just because somebody's experienced abuse that's relevant to what they're accused of doing, it doesn't mean that introducing it is going to be helpful to her case. In fact, sometimes it could be harmful, and we will get to that. The lawyer's going to have to think about if there's anything in the case that maybe doesn't have to do with the charge itself, but that could be helped out by expert testimony. At the clearinghouse, we tend to call this stuff bad facts. Is there anything confusing, anything puzzling that could be explained by talking about the dynamics of domestic and or sexual violence? In other words, what can an expert do to help support the defense theory of the case? So a lawyer has all these questions on his or her plate. The reality is that before hiring an expert, a lawyer might not be able to answer those questions. An expert may be on board, maybe needed to be on board to help go through those questions and answer them in a way that makes sense. Because after all, the judge and the jury might not be the only ones who need some education about domestic violence and the role that it can possibly play in a criminal case. There's a lot of other things an expert can do as well. There's some experiences that the defendant has had that maybe the lawyer might not know how to ask about or to find out about. There might be things about the case strategy that the advocate is, or excuse me, the expert is going to have a different set of eyes on. And you know, there's this other piece too, where, you know, if the defendant has undergone trauma, there might be ways in which the advocate can help the defense attorney know how to work with that client in a way that's going to be helpful to their case. So I bring up all these things to emphasize that for a defense attorney, getting an expert involved as soon as possible, whether or not testimony is ultimately going to be needed is what we recommend, and it's usually the way to go. And the short version of that is you don't need an expert. You don't know if you need an expert until you actually get one. Okay? I hope that makes sense. So defense attorneys also have to look at the downsides of introducing expert testimony. Are there going to be harmful things about the case that can come out if an expert gets introduced that wouldn't have come out if an expert wasn't introduced? Like, does she have any, I don't know, ex-boyfriends who might now be called to testify about what she may have done to them in the past? In other words, does the benefit of calling an expert outweigh the potential drawbacks? And an attorney also has to know exactly what kind of experts he or she is going to need. As we saw while answering the poll questions, people who have expertise in domestic and sexual violence come from a multitude of professions. You know, we have psychologists on this call, we have advocates, we have educators, we have other people. And who is going to have the most ideal background might vary from case to case. Everybody might have expertise on domestic violence, but there might be something about any one given profession that makes one expert more appropriate for a case than another expert. I stated earlier that we're looking at defense testimony, particularly by advocates who testify as experts. So before we go further, I do want to say a little bit about defendant-specific versus general testimony. When experts are providing what we call defendant-specific or sometimes case-specific expert testimony, they're actually talking about the incident that's at issue in the case. They're talking about the defendant. They're talking about the parties. Usually, though not always, these folks are people with professional backgrounds involving forensic evaluation or psychological evaluation. Now I say usually but not always because that's true. We know people from other professions sometimes do evaluations of defendants as well. But the point of bringing this up is to say that most of the time advocates don't provide defendant-specific testimony. So most of the time what we see is domestic violence advocates providing general expert testimony. And what I mean by that is they talk about concepts, okay, domestic violence concepts that might be extremely relevant and on point to the case being heard in court, but they're not talking specifically about the people in court or the incident that's at issue in court. I have an example here. Based on your professional experience, can you give some reasons why someone might not leave an abusive relationship? So that expert witness is going to answer based on her expertise, but she's not going to say the defendant didn't leave her relationship because X, Y, Z. Okay? I said earlier that there's a number of different professionals that have expertise in domestic and sexual violence. This might seem like a no-brainer, but it's important to be able to frame exactly what you consider your expertise to be. And the reason is that when the attorney is going to the court and telling the court that he or she needs to be allowed to have an expert testify in the case, he needs to be able to say an expert on what. Now, this is a situation where sometimes terminology can get in the way. But what we don't want is lawyers going into court and asking the judge for funding for an expert for an expert on battered women syndrome, and then have an expert coming in and saying, no, I'm not an expert on battered women syndrome, I'm an expert on domestic violence and sexual assault. So it's just a matter of making sure that experts and attorneys are on the same page about what the proffered expertise is going to be. And I'm going to be talking about this more a little bit later, but sometimes there's magic words. And what I mean by that is sometimes there's local and state laws that dictate what the lawyer has to put forward in order to get expert testimony admitted. Some states have language using the term battered woman syndrome. So sometimes, even though an expert might not use that terminology or that framing, the lawyer is required to present that that terminology and that framing. So I want to talk now about some ways in which testifying on behalf of the defense is similar and perhaps different to testifying on behalf of the prosecution. In both situations, an expert is probably going to be talking about behavior that might otherwise be puzzling to the jurors. What often becomes relevant in the minds of the jurors and the judge or whoever the fact finder is why battered women sometimes stay in abusive relationships. This phenomenon can come up on either side of the aisle. On behalf of the prosecution, the jury might not believe that she was actually assaulted if she chose to remain or go back to her abusive partner. So it kind of goes to her credibility. On behalf of the defense, it's the same thing. If she's putting forward a self-defense theory, the jury might not believe that she was in fact struck first if she was willing to be in that same household with that abusive partner. So on both sides of the aisle, that issue can definitely be one that an expert witness is crucial to be there. Help seeking or calling the police, disclosing abuse. These issues are definitely something that experts on behalf of the defense and prosecution might encounter and might have to explain. Now, on behalf of the defense, what we tend to see, and some people might disagree with us, but that there might be a wider range of issues that the expert is called upon to testify to, and that's because the charges and the factual scenarios for which people are charged can range so significantly. Okay, these cases can be all over the board, and so there might not be a short list of topics that the defense attorney is going to need the expert to be able to speak to. There are some cases where a specific professional background might be required or at least preferable in any given case, just depending on what the jurisdiction is going to allow and what the case calls for. There's also defense cases where the lawyer is going to need that forensic interview that I talked about earlier. Now, again, that specifically depends on what kind of case you're looking at, and it might depend on the law in the particular jurisdiction. And I want to just pause for a minute and say that when that defense attorney calls you, he or she might not know what they need. Okay, so this is definitely an important question for experts to be asking attorneys up front. They might know you're an expert on domestic violence and just make the assumption that you're able to give them whatever it is they're going to need as the case moves forward. And in the end, it may be that somebody else is a more appropriate expert than you. So asking that question early can be something that's really helpful. And then even though, in our world, it feels like, certainly here at the Clearinghouse, and I know in all of your roles as well, we see battered women charged with crimes all the time, okay? But in the world of criminal defense, it's been our experience that most criminal defense attorneys haven't tried a quote-unquote battered women's case before. So when you're working on behalf of a prosecutor, I would hope that that prosecutor has prosecuted domestic violence cases before. And sometimes the prosecutor exclusively prosecutes domestic violence cases, but the defense attorney may have never actually done this before, even if he or she has been practicing forever. So it can be very, very new to defense attorneys. Now, there's a wide range of practice about what an attorney has the expert know going into court. And I'm still talking about general experts here. We know that in some situations, the expert doesn't know anything at all about the case, not even the party names. He or she just gets on the stand and answers questions about domestic violence and sexual assault based on his or her experience. Sometimes there's at least been a conversation about the bullet points in the case, what the lawyer is going to want the expert to cover. And then sometimes the expert has the defense attorney's entire case file, okay? Now, that doesn't mean that they're going to testify specifically about what's in that case file, but they have it for background information to give them an idea about what is going to be salient to the case in court. Now, a lot of experts and the agencies they work for have policies, either written or not, usually not, I think, about which approach they take. And there's definitely ups and downs to each approach. I'm going to give you my opinion for what it's worth about which one is better. But suffice to say for now that every case is different, and what is needed in any given situation is not always going to be what a particular individual expert or his or her agency can provide. So for that reason, I just feel, and I'll talk more about this later, but I just really feel like for when you're testifying on behalf of the defense, knowing something about the case feels really important to me. And people do disagree with me. So what I'm not saying is that defendant-specific testimony is always going to be better than general testimony. I know I said that in a lot of defense cases, defendant-specific testimony was called for. But that's because sometimes there is this need that the expert can help fulfill of connecting the dots between the defendant's experiences of abuse and what, in fact, they're charged with and what their defense is. If an expert can get on the stand and talk about the case specifically, a lot of attorneys think that jurors are going to have an easier time. That's not always the case, but that can definitely sometimes be the case. And then the other piece is that, in so many cases that we work on, people who do forensic assessments can learn helpful things that the defendant may not have disclosed earlier and that the lawyer might not otherwise have discovered, okay? So that's just, it's another upside. It's not to say it's a deal breaker, making one style better than another, but it's a factor to consider for sure. So let's spend some time talking about some of the more common kinds of criminal defense cases and what the experts do in those particular cases. I said earlier that I think that the primary kind of case that people think of when they think of battered women charged with crimes is self-defense cases. And, you know, I have up here a picture from the movie Sleeping with the Enemy, which you really couldn't get any more stereotypical than that movie. I don't know if y'all saw it, but the battered woman was this beautiful, rich, white lady who doesn't fight back, cries a lot, and manages to escape by faking her own death. Yeah, you know, what we see every day. But, you know, these are the ones that we think that maybe everybody understands. But what we know, if we work with battered women who are charged with crimes, is that no, self-defense is not a no-brainer for people. There tends to be this view out there in the world, and by in the world I mean including in the minds of some judges and some defense attorneys, that there is self-defense and then there is battered women's self-defense. And the way that those two things are different is that self-defense is normal self-defense, and battered women's self-defense is where she snapped and retaliated or killed him while he was sleeping. Well, no. There's no special self-defense for battered women. There's no situation under which if you prove the defendant is battered, then you win. That is just not how it works. Instead, and with the help of an expert witness, in battered women's self-defense cases, just like everybody else's self-defense cases, defense attorneys have to show that the defendant was in fact in imminent danger, and that her fear of harm was one that was reasonable. Okay. So there's a lot of ways that an expert can help support a self-defense case. First of all, as I said a second ago, the defense attorney is going to have to show that the defendant's assessment that she was in imminent danger was in fact accurate, and why that apprehension was accurate. We know that this can be a problem for battered women because battered women may know things based on their experiences and based on what they know about their partner that people from the outside looking in might not be able to see. Expert witnesses can be crucial in explaining this. How, you know, in their experience, a defendant becomes a really good assessor of the danger that she's in and all the reasons that underlie that. An expert can also help a defense attorney give alternate explanations for what might appear to be inexplicable behavior. And either that behavior can be something that's really confusing to the jury or something that the jury looks at as an indication of guilt. One example I can think of is a case we worked on where right before the defendant needed to act in self-defense, she asked her children to go outside. Okay. Now the prosecutor jumped right on that to say that, oh, that means she premeditated his murder. Where an expert witness could contextualize that a little bit. She didn't premeditate murder. She premeditated the fact that she was about to get hurt. Okay. So it's this way of providing alternate explanations for inexplicable or seemingly incriminating behavior. In the same way, an expert can help to rebut harmful inferences that the prosecutor makes. This is really similar to helping to offer alternate explanations, but it can come up in different ways. So a harmful inference a prosecutor might make about whether or not someone could have left an abusive or dangerous relationship. So I don't know if that makes sense or not, but the prosecutor might ask the jury to infer that either she's not credible, that the abuse wasn't bad enough, or whatever, by the fact that over 20 years the defendant chose to remain in that particular relationship. This one is always perplexing to me because whether or not someone could have at any point left an abusive relationship is not an element of murder or of self-defense. In no other self-defense case is somebody asked whether, they could have avoided going to that dangerous neighborhood or that, that bar where, people with weapons hang out. It's not a piece of the case. but it's something that's used against battered women, and therefore it's something that experts can definitely help with. There's also this piece about factors that come up that juries may use to undermine either the defendant's credibility as a whole, or, this is a little bit more intangible, but the defendant's worthiness, I guess, to employ self-defense. Okay. Again, if she voluntarily stayed with her abusive partner, is the jury going to care that she acted in self-defense? I mean, I don't know. I think that by hearing about the realities of a battered woman's experiences from an expert, a jury might be able to make that decision a little bit more properly. Inconsistent statements or lies. Every case has inconsistent statements in it in some kind of way from some party, whether it's the defendant or not. And sometimes those things can be used, obviously, in ways that are not helpful for the defense. But just because somebody gives an inconsistent statement, it doesn't mean that they weren't battered, and it doesn't mean that they didn't act in self-defense. Again, there's this moral thing happening. If somebody, at first, says that they don't know what happened to their abusive partner, but later on admits that they acted in self-defense, does that mean they're not battered? No, not necessarily. So that's a role. That's a really important role in some cases for expert witnesses. Let's move on to another kind of case that we happen to see all the time. In criminal court, but also in our jobs in the anti-violence movement, we see battered women forced to do things that maybe they were never charged for. But we understand that abusive partners use threats and coercion to get battered women to do things, some of which are illegal. For us, this is a really common sense concept, but the law really, really struggles with it when you're in court trying to assert why a defendant should be excused from behavior that would be otherwise criminal. Let me say that again in a different way. When somebody's asserting a defense of duress, what they're saying is they had no choice but to participate in the crime because they were coerced by someone else through the use or threatened use of imminent physical violence. Okay? So this, there's not just one kind of situation in which this comes up. There's, this is a short list of the kind of charges that we see battered women facing who have been coerced into participating. We see a lot of drug dealing, bad checks cases. There's been a rise in federal prosecution of straw purchasing of guns, meaning somebody buying a gun for somebody else because that somebody else is a convicted person or otherwise barred from buying their own gun. So battered women, sometimes buy weapons for their abusive partners. Participating in human trafficking, robberies, burglaries, you name it. Sometimes even homicides. Although, duress is not always going to be a defense to homicide in every single state. That's just a side note. Experts are helpful in duress cases in much the same way that they're helpful in self-defense cases. So we're still talking about her assessment of the danger that she was in, right? That analysis is pretty much the same as a self-defense case. But there are unique things about duress cases. So I want to go through some of those now because experts can be really crucial for some of this stuff. A lot of states have duress as a defense, but they disallow the defense if the defendant recklessly placed themselves in a situation under which they should have known they were likely to be coerced into doing something. I know that's a mouthful, so let me say it again. A lot of states disallow a defense of duress for defendants who recklessly place themselves in a situation under which they should know they're going to be forced to commit a crime. So battered women get undermined by this. We've seen it way more than once, unfortunately, based on that same old that we always hear about. Well, she chose to be with him. Okay, she chose to be with him. The idea is, well, she put herself in that situation. She knew he was a bad guy. So experts can really help talk about how, in fact, it's not that simple. It's not about choosing to be with somebody that you know is going to go on a crime spree. There's a lot of reasons why battered women are in abusive relationships that have nothing to do with being reckless or knowing that you're going to be forced to commit a crime. The person of reasonable firmness. I don't know who this person is. I really don't think it's me. But it's written into a lot of statutes dealing with duress to try to say that if a person of reasonable firmness could have resisted the duress or coercion, then you're not going to win that defense. Okay? So the way that this gets used against battered women is by prosecutors arguing that defense attorneys are trying to assert a new standard. Defense attorneys, by calling an expert witness, are trying to say, oh, you're trying to argue that battered women should be the objective reasonable person here, and not this person of reasonable firmness. No, it's not, and that's just kind of a legal error. Defense attorneys aren't trying to replace the standard. What they're trying to do is what they're entitled to do, which is have the jury evaluate the reasonableness under the circumstances of the defendant. Okay, so I know that's a little bit confusing, but that's one way that prosecutors even try to keep out expert testimony, is saying that defense attorneys are attempting to create a new standard. Ongoing threats and coercion. Experts can help to show how even if a batterer is not standing there next to the battered woman, the threats and coercion that he has inflicted upon her can still be very real and not in her head and not fictitious. Experts can show how battered women are sometimes placed under a state of siege where they don't know when the next attack is going to happen, or they don't know where their abusive partner is. So even if he's not physically standing right next to her, it doesn't mean that there's not a real danger there. And I want to say that duress can be really hard to prove, because what the jury is looking for is somebody who's going to die immediately if they don't participate in the crime. Well, those kind of cases are rare for battered women, and they're, at least on the surface, but they're also rare for all defendants. Most of the time, the co-defendant or co-perpetrator or the person who did the coercing is not standing there threatening death within the next millisecond without the participation. But that doesn't mean the threat's not immediate, and that doesn't mean that the threat is not very, very real. I've already talked about some of the stuff, what experts can do in these cases. I just want to make one more point about that. When arguing these cases, defense attorneys can do this, and they can also use their experts to help explain that remaining in an abusive relationship is not the same as voluntarily participating in an ongoing criminal enterprise. And I bring that up because of that recklessly placed exception. That exception was built into a lot of state laws to try to capture, I think, mostly gang members. So if you join an organization where the whole point of the organization is to go out and commit crimes, then you can't go back and say that your gang mate forced you into doing something you didn't want to do. It's not about whether or not somebody, quote unquote, chose to be in an abusive relationship. And making that distinction can just be really, really helpful. Let's move on to what we call non-traditional self-defense cases. And by non-traditional self-defense cases, I mean sometimes they're they're self-defense in the way that we in the anti-violence movement think about it, but they might not be self-defense in the way the law thinks about it. And these are the cases that come up for some people who don't really have a nuanced understanding of what self-defense looks like for battered women. Sometimes they're only thinking about cases where the abusive partner was sleeping or where the battered partner had to hire somebody to kill her abusive partner. These are tricky, and I'm not going to say that they're not. I only have 3 challenges written down here for why these are hard, but there's about 1 million of them. There might be some difficulty getting a defendant's experiences of abuse admitted in these kinds of cases because the court might struggle with relevancy. Because you're not imminent, you're not necessarily talking about why her fear was reasonable in that moment if he was sleeping or if she wasn't even there, if she hired somebody to kill him. So that can be hard. We see expert testimony precluded all the time based on that. We also see a history of abuse as something that's used by the prosecutor as a motive to kill. They know that the defense is going to struggle with a self-defense case, so they concede that the decedent was very abusive, but they use that as the reason she killed him in order to get the conviction. And then there's also the element that's present in first-degree murder cases around premeditation and deliberation. So, in a sleeping man, definitely in a hire-to-kill case, and arguably in a sleeping man case, the prosecutor might have a pretty good argument that the killing was planned. And like I said, these are hard. They're not going to always let in the expert testimony, but sometimes they are, and it can definitely be very helpful even if it's only presented at sentencing. An expert can help the judge or jury understand the state of siege that the defendant was under. And that there wasn't, in fact, a safe way to escape. The expert could also help illuminate some things about the case that might be glossed over or misunderstood without the expert testimony. Like what was his pattern of abusing her? Did he always beat her up in the morning? Did he pretend to be asleep when he actually wasn't? We've seen that before. Did he, threaten to kill her in the morning? We've seen that more than once. So what is it about that case that narrowed her options to the point that what she did was the only possible way she could stay safe? It's important to remember that sentencing judges want to know why somebody did what they did. So even if this stuff doesn't come out in trial for whatever reason, it can sometimes be really helpful at sentencing. It might not be something that's a complete justification or excuse, but it might really help. And I will say, even though it's rare, we have seen acquittals in these kind of cases too. So nothing is off the table. I just want everybody to remember that these kind of cases are tricky and hard. Failure to protect cases. I know that a lot of us on this call have some experience with these. I want to be clear that I'm specifically talking about criminal court cases, not cases in CPS or dependency court, but criminal court cases where battered women are charged with crimes for the acts of somebody else, where the law thinks that the battered woman should have done something in her role as mother or caregiver to intervene with the abuse or to get help for the person that was harmed. Unfortunately, we see this issue all the time. Battered women get charged for the criminal acts of their abusive partners. In fact, we even see battered women getting sentenced higher than their abusive partners, even when they didn't participate in the abuse at all. And I'm sure we're not the only ones who see that. Under this theory of failure to protect, the battered women are prosecuted and face the same consequences as if they actually did it. So experts can be crucial in these cases. And not just in the ways that they are in other cases where they help the jury see the reality of a battered woman's life and experiences, but in addressing things that might be unspoken or intangible. Things that you're never going to talk about, but a jury is going to understand better because of the expert testimony. Based on our experience, we think that mothers are held to a pretty darn high standard. And so without some explanation about the dynamics in that household, the mother's going to be seen as the worst person in the world if she fails to protect her child from her abusive partner. Even some of the members of the jury who might have their own experiences of domestic violence might do some unconscious line drawing about what they would or wouldn't have done if a child had been involved. Sometimes cases involving harm to children can be deal breakers for people, like I just said. And this doesn't just go for people who have experienced abuse, but sometimes lawyers and even domestic violence advocates too. We don't like to see kids get hurt, obviously. And so when we see that, somebody has to pay. So advocates can really, when they testify as experts, can really help to contextualize what was going on, can help understand behaviors that may have looked ambivalent or harmful, but show how they may have actually been protective. Okay? These are cases in which sometimes case-specific testimony might be required because, like I talked about earlier, that dot connecting. Why is it that this woman, by sitting there and not calling the police, was doing something more protective than had she called the police? An expert might be crucial in helping to explain that particular dynamic. Failure to protect cases are hard. An expert doesn't end up helping the lawyer explain why somebody did what they did. They end up explaining why somebody didn't do what they didn't do. People can't often wrap their heads around these cases involving inaction that's illegal as opposed to action that's illegal. So these cases can be really, really hard to defend. Sometimes in failure to protect cases, particularly the more serious felonies, the law states that in order to convict somebody, that person has to actually intend the harm or sometimes even the pain. So they have to actually intend what ends up happening to the child. Experts can really help to offer alternate explanations and also to negate that mens rea or that state of mind. In these failure to protect cases, battered mothers aren't not acting because they wish the child to come to harm, but for a lot of other complex and hard to understand reasons that in fact may have been the most protective actions they could take. The example I gave earlier was the mom who didn't call the cops or seek medical care. How much worse would his abuse of the child have been had she done that? Experts come in and explain how that can be so. And that's not a concept that's easily embraced or understood, which is why experts are so crucial in failure to protect cases. It's important to remember that lawyers don't always call experts to try to get a full acquittal. Sometimes that's not a realistic goal. That can be hard to swallow, but it's true. Sometimes an expert is crucial in reducing murder to manslaughter, for example. Sometimes the court might not think that a case rises to a full self-defense, but they can buy that the defendant acted in heat of passion inspired by fear. So sometimes the goal is just to reduce the culpability and reduce the exposure that the defendant has to sanctions in prison. Advocates who testify as experts can struggle with this because it can feel like a real sellout. We know why the defendant did what she did, so why are we saying that she should be found guilty of something? It's tough. but sometimes that's the most realistic outcome and the best course of action. And sometimes that's what you can do to help avoid much, much more harsh consequences. Here's a hard one that we see all the time. What do you do when the allegations against the defendant are just completely made up out of whole cloth? We see it over and over again, and it feels like we're seeing it more and more. Some abusive partners are really good at getting their victims arrested for things that just never happened. Not a self-defense case. It's a she didn't do it case. They can even get their own witnesses on board, maybe their new girlfriend or maybe their mom or maybe their buddy can lie for them. We've even seen abusive partners injure themselves in order to get the victim locked up for assault. And then once there's a protection order in place, it just becomes easier and easier to get the cops to arrest. If there's a protection order, maybe at least on some level, there's an assumption that the person against whom the order is issued is the abusive partner, so the other person must be telling the truth. Okay, so we see this all the time, and I want to say that we take it for granted, but people who don't have the understanding we do about the dynamics of domestic violence can't understand how these arrests happen even when there's little to no evidence, or when there is evidence, how it could have been fabricated. As a public defender, I had cases where the complainant injured themselves. Nobody believes that somebody would injure themselves, but you know that we see that all the time. And going forward to court with that defense, like he punched himself in the face, it doesn't barely pass the laugh test, right? But we know that it happened. Sometimes it's hard in these cases to articulate a role for expert witnesses because there's not that behavior that's there to explain. She didn't do it. It's not, oh, she did it because. It's she didn't do it. Experts would always be able to talk about why batterers do what they do, but the court's not always going to allow that, talking about why another party may have done what they did or didn't do. It's just probably not going to be admissible in a lot of contexts, although we have heard about it in a couple situations. In all cases, and I've already talked about this a little bit, there's other puzzling behavior that experts can definitely help with. I have inappropriate emotions in quotes, and the reason is because I don't really know how somebody who is just acting in self-defense is supposed to act, because our battered women defendants never seem to get it right, okay? If they cry, then they're crocodile tears. If they laugh, then they're cold-hearted monsters. If they have no affect at all, then they weren't impacted by the brutal murder that they just committed. So I don't know how they're supposed to act, but expert witnesses can come in and talk about how victims of ongoing battering can display wide ranges of emotions for a wide range of reasons, and if the expert has the appropriate background, can talk about the impact of trauma and how that can affect demeanor as well. Lawyers can also use experts to talk about supposedly disproportionate uses of force. This dynamic happens a lot in battered women's cases. Prosecutors try to rebut self-defense theories by talking about the fact that the decedent or the complainant didn't have a weapon, and she did. Well, yeah, this one also feels like a no-brainer to me, but it's just not. If she had a weapon and he didn't, then the argument is going to be that she wasn't in actual, real danger and that she overreacted and that she should be found guilty. Well, expert witnesses can help the defense attorney show how real the danger was and how, all the numerous times in the past that he hadn't used a weapon, she may have still been hurt very badly, or how his threats to harm her were things that were credible to her and for a very good reason. When defendants don't act like they should, when they seem like they're tough, particularly when police arrive at a crime scene or an alleged crime scene, and the abusive partner is calm as a cucumber, and the battered woman is losing her mind, that can be used to infer that she was the bad actor in that circumstance. So an advocate can definitely help normalize that kind of behavior and show that it's not inconsistent with being somebody who is a victim of ongoing battering. Co-defendant cases. Call upon expert witnesses for an even wider role because they present their own unique challenges. When I'm talking about co-defendant cases in this circumstance, what I'm specifically talking about is are battered women who get arrested along with their abusive partner for doing something. In other words, the defendant who's battered is co-defendant with that abusive partner. You can just imagine the million things that come up to make this particular situation complicated. First of all, an advocate who testifies as an expert can work with the attorney to understand whether or not the battered defendant can meaningfully participate in her own defense. And I'm not talking about competency to stand trial here. I'm talking about, is she going to be too afraid of her co-defendant to give her attorney what the attorney needs in order to be helpful to the case? Or is fear of repercussion or the co-defendant's mere presence going to have a chilling effect such that she really can't help her lawyer prepare her case? There's a couple of cases around the country that have made it to appellate courts where this has happened. There's other cases that aren't necessarily published situations, but cases we've heard of where, as soon as the case is over and one party and or the other is incarcerated, the true story comes out because now the battered defendant feels very safe. So answering that fundamental question can be something that an expert helps an attorney do. Evaluating statements that the battered defendant has made is something that we've seen come up. Is the battered defendant covering for her abusive partner, particularly in cases where she takes full responsibility and it looks a little bit fishy? Is she covering for him, and why is she covering for him? An expert can help to evaluate that. Is there going to be a conflict of interest? I can't tell you how many cases we've seen where co-defendants who are intimate partners are, at least at first, represented by the same attorney. Well, when one of the partners is battered, that's just not going to work. So an expert can help evaluate that. An expert can also talk to the attorney or help the attorney brainstorm about the pros and cons of keeping the cases together, or trying to separate them. On the one hand, if she's too scared to participate in her own defense, she might not want she might not be able to, do anything effective at all if her abusive partner's in the room. On the other hand, does she have a tactical advantage of having him in the room? So that one's tricky. And then this comes up all the time too, plea bargaining. In some of these cases, the prosecution might know who's the more culpable of the two or might suspect the battering relationship, and so they might offer the battered defendant a deal in order to testify against the abusive partner. That can be tricky because she might just be too scared to do that. Or she might think she wants to do that but then be unable to do that once she's actually facing him in court and facing his attorney on cross-examination. And then there's this idea of wired pleas. And I knew about this phenomenon, but this is actually a term that I learned today. A wired plea is a plea bargain in which one party has to accept it in order for the other party to get it. It's, on its face, it's not been held to be unconstitutional to do this, but it's just really coercive. if someone's abusive partner is 10 times more culpable than her, but they both have to take a relatively high plea in order for him to get what's a good deal, she might definitely end up getting the raw end of that stick, but might be too scared to say no, because if she says no, he doesn't get the deal. So evaluating these things and deciding how to proceed can require the assistance of someone with expertise on the dynamics of battering. I see that I only have a few minutes left, and I know I've been talking fast, so I'm just going to go ahead and keep on doing that by sharing a couple tips that might help navigate common situations that come up when testifying on behalf of the defense. Again, people might disagree with me, but I think it's so important that the defense expert know what the theory of the case is, and here's why. When you're testifying, even giving general testimony, what might seem obviously helpful and relevant ground to cover can be really harmful if it ends up supporting the wrong theory. Okay? I had a case as a public defender, and long history. It was a same-sex case. It was two men. A long history of abuse by the complainant against my client. The complainant beat up my client all the time, and sometimes my client defended himself. Okay. One day, I don't know what the trigger was, but the complainant decided to go to the police and talk about this incident that happened in the park where my client punched him in the face. He punched him in the face in self-defense. Okay. But because the complainant did this not right after it happened, but some months later, in an effort to try to find another way to abuse my client, he muddled some of the facts and he got the date wrong. Okay, I actually had an alibi for what my client was doing when he was supposed to be at the park beating up the complainant, and I brought in the alibi witness. He wore a suit. It was fantastic. But if I had called an expert and not shared what my defense was with the expert, and the expert started talking about reasons that victims of ongoing battering defend themselves, that would have been something that was really harmful to my case, because I wasn't going with that. I wasn't going with the fact that he defended himself. So I think that when there's not at least a roadmap for the expert witness might subconsciously try to anticipate where the defense attorney is going with the line of questioning, which can be really helpful unless the expert gets it wrong. Okay, so to me, knowing the theory of the case is something that's just really, really important. Let me go back. Sorry. Battered women syndrome. Make sure the attorney that you're working with knows the framing that you use to talk about the dynamics of ongoing battering or intimate partner battering and its effects. Make sure that they can anticipate the language that you're going to use, and also know that there's situations where you might have to be a little bit flexible in order for the evidence to get admitted into court. It's not saying that you have to buy, the research from 1978. What it is saying that you might have to work with the attorney to know how to frame the evolution of the science behind battering and its effects. Okay, so just know that sometimes there's magic words. Sometimes the attorney might be required to say them, and work with the attorney to know how to introduce your expertise while still fulfilling the evidentiary requirements. Grumpy Cat. Grumpy Cat hates surprises, and so do expert witnesses. We've heard this over and over again. If there's bad things about the case, even if they're presented in a hypothetical fashion by the prosecutor, the expert's probably going to want to know them. So if defense attorneys know that they don't have to sell you by painting you a pretty picture, and that you'd much rather know the bad facts of a case, that can be something that's helpful. That way, when things come at you, you're going to know that they're coming and know what to do with them. Resist attempts to get you to testify beyond your expertise. We've seen this a few times. We know that when we're working with battered women, we see a lot of things, obviously, but that doesn't make us an expert in a lot of things. So lawyers can be tempted to push and push about what you're an expert on and what you're not an expert on. And it will just undermine your credibility if you start testifying to things that you don't consider yourself an expert on. One common example that was given by one of the trainers at this great expert training I just went to in Michigan is that a prosecutor was asking her to talk about the impact of substance abuse on battered women, and she just wouldn't do it because she's not an expert on substance abuse. If you're not an expert on PTSD, then your testimony probably shouldn't go there. If you're not an expert on the impact of childhood sexual abuse on adults, then that might not be an appropriate area of your testimony. So it's important for the lawyer to know what you do have expertise in and what you don't have expertise in. I know that the truth is the truth. What we know about domestic violence is what we know about it, regardless of what side we're testifying on. But when somebody is facing a criminal charge, they're entitled to the assistance of experts, and they're entitled to the assistance of their own experts. The legal system is an adversarial system, and so if you're hired as a defense expert, you're now a member of that defendant's legal team. You're not a resource for everybody who wants to tap into you. So it's just important, if the prosecutor wants to talk to you, or if the court contacts you ex parte, without the lawyer knowing, it's just important to have some guidance from the lawyer about what your role is in terms of sharing your expertise before you actually get on that stand. Okay. And then finally, it's okay for you to have requirements and to say no to cases that you just can't do. It's totally reasonable for you to require prep sessions with your attorney, for example. They may really need you, but if you can't get on the stand and be the credible professional expert that you are without having things like prep sessions and communication in place, it's totally okay for you to say no, and I just wanted to say that out loud. And with that, I think I will stop, and it looks like we do have a few minutes for questions.
We do. Thank you, Cindy. That was terrific. It was really, really helpful information, and it's just a great presentation, so thank you. Yeah, we do have a bunch of questions. Let's see if we can get to all of them. Some of them will, I think, take offline afterwards, but the ones, I'll just start actually from the top of my list, and we'll work our way on down, okay?
Okay.
All right. This is from Leah, I think is how she says her name. I had a defense attorney across the state want me to come testify as an expert, but expected my program to pay the expenses. What are the common practices around this? And then she added, luckily this case was settled out of court.
Luckily. That's interesting. I don't know that I've heard of that particular expectation before. In a lot of states, depending on whether or not the defendant has money or doesn't have money, experts can let lawyers know that they can petition the court for funds. This is something that the lawyer should already know, but defense attorneys don't have the same kind of experience that civil attorneys have in calling experts, so they might not actually have this information. You can definitely, if you come across that again, you can definitely refer defense attorneys to the National Clearinghouse, and we will work with defense attorneys on how to ask the court for money to pay for expert assistance. That is not something the program can be expected to shoulder. It's something that for indigent defendants should be a cost of the court.
Yeah, I have to say, in all my years of doing this work, I have never heard of that.
Me neither.
Yeah. So that, Leah, what state are you in? Maybe you can type it in. That's just interesting. That was new for me as well. So while she's doing that, let me go on to the next one, okay, Cindy?
Uh-huh.
Robert asked, Has jury research been done on juror acceptance of expert testimony on topics like why a battered woman did not leave or why she did not call the police, battered woman syndrome, etc.?
There has, and maybe other people have some information about this, there has been some research that has been done on jurors' acceptance of expert testimony, but it's something that's really, really hard to quantify because it's really hard to replicate the juror's situation, and you can't look at a jury's reaction to expert testimony based on outcome alone. Like we've definitely had cases where the jury has loved the expert but is still convicted. So there's at least one or two articles that I know about, but I don't know how much information that actually gives you about what jurors do with the information that they receive. Sue, do you have more information on that?
My experience is that the research studies that have looked at the issue of, acceptance of expert testimony, if you will, primarily use college students in scenarios. And I just think that's going to give us some information, but I don't think it's going to give us particularly good information about how jurors would actually act with real cases where there were real consequences to their decision making. So I agree. It's really complicated, and you can never have a control group in real life. So it's very difficult to do good juror assessments. So, Robert, we can share with you the research we have, but like I said, I think it's all based on college students. I mean, maybe some of the other people on the webinar have other suggestions. If so, you can add it into the chat box or send it to us later, and we can share it back with you all. But I just have not seen particularly good stuff, and the stuff we have is quite old, frankly.
Yep.
Okay, and Leah is from Oregon.
Okay.
Okay.
Yeah.
Nina, I don't know if you saw my follow-up questions to you. Her question, Cindine, was, we are having trouble, and she's in Missouri, I assume she's still in Missouri, I guess. We are having trouble having advocates certified to testify as an expert in DV cases. Any tips on how to do this?
By certify, I mean, that could mean one of two things. Some states are trying to have a training program for advocates to receive, like a coalition-sponsored certification to testify as expert witnesses. But she might just mean qualified?
Because I asked her, Nina, are advocates in Missouri certified? Is there a different certification process for experts? And she just answered, thank you, Nina, we don't have certification, but basically getting the courts to accept them as experts. Okay, thank you for the clarification.
Yeah, thank you. I guess people struggle with this in different states, and it depends on what the particular stumbling blocks are and what kind of cases you're talking about.
And Cindine, can you keep your voice up, please?
Oh, sure. It depends on what the court's stumbling blocks are, and there's some common ones. Sometimes judges will think that testimony about domestic violence has to involve battered women syndrome and therefore has to involve a psychologist or a clinical social worker or something like that. So sometimes it's not about the expertise of the witness, but it's about their professional background. So it's going to definitely be on the lawyer to really look at what the law is and how to strategize about making sure that they're clear about what kind of expertise they're offering and what they're asking the expert to do.
Cindine,
yeah?
I'm sorry. Nina added professional credentials are not sufficient, is what she added.
Okay. I'm happy to talk to you, Nina. I'm going to need to know more about where the judges are getting hung up, because judges could get hung up on advocates' role as advocates. Okay, and so then the proffering attorney is going to have to talk about how they're not testifying as advocates, they're testifying as expert witnesses whose experience is grounded in training and working in the field, just like a lot of other areas of expertise. Professional credentials for any kind of expert testimony are usually not going to be sufficient. You have to sort of show where the expertise comes from, what it's grounded in, what research is based off of, and that kind of thing. Another stumbling block can be that judges don't see the expert testimony as reliable. We haven't seen that a lot, but we've seen it in different circumstances. So it's on the attorney calling you as an expert to talk about how working in, it seems like a no-brainer, but how working in the field gives one insight into dynamics of domestic violence. An expert also might have to be really careful to be able to back up their observations that they've seen working with victims of ongoing battering. In other words, in some states it's not as important, but in some states you really have to know what the research is and what the state of the art is. When we say things like, the most dangerous time for a battered woman is when she attempts to exit her abusive relationship, be able to say who says so. Because some judges won't be cool with you knowing that based on your experience. You're going to need to cite to the literature. So if I have more specifics, we can brainstorm about how to navigate the problems that you're having in Missouri. Okay, great.
So that would be great to talk more. And I mean, I think what Cindine you're saying is just so important about really knowing the ins and outs of your local legal culture and really what is going on with your court system and what are the stumbling blocks. And they really vary from community to community and state to state.
That's right.
A couple of more questions here, which we may not be able to get to them all. I apologize. Linda asked, are there liability issues in being an expert witness that agencies should be prepared for?
Liability issues. It's a good question. I can't, at least from the criminal defense perspective, I can't necessarily think of any. Well, let me back up. If there might be liability issues if by testifying you're breaching confidentiality in some kind of way. Okay, and I'm certainly not an expert on how that can play out, but we have some earlier webinars on some thoughts to consider when asked to testify. We generally don't think that advocates who have worked with specific battered women should testify in their cases as expert witnesses. So you avoid, just not testifying for people that you know or for people that you've worked with or for people who your programs worked with can avoid liability from that end. A defendant might have a cause of action against his attorney for malpractice, but that's against his attorney. I can't think of a case where the defendant could assert anything against their expert witness. It's really on the attorney to hire the appropriate expert witness. Sue?
No, that's a new one for me.
Okay.
Good question, Linda. And
yeah.
Good. And if anybody has anything else to add to that, we'd really love to hear from you. There was just before I go to the last question here from Ann, quickly, Linda asked about if we've ever heard of culturally specific expert witnesses, and I said yes, and that would be great to do another webinar on that.
Yeah.
So we have been talking about that, and we're trying to line up a couple people to talk about it and pros and cons of having a culturally specific expert. So Great question, Linda. And Ann, and we're going to end with this one, is her question was, are there legal consequences for serving as an expert for the defense of a client who is receiving clinical and other support services from the agency you are employed by? And I asked a follow-up question, and she said that she's worried about consequences for the survivor defendant. Will the testimony of an expert who is employed by an advocacy organization be perceived as biased or tainted by the clinical relationship? Is it beneficial to have an expert who does not have a clinical/professional relationship with a survivor defendant?
Okay. That's a great question, and the short answer is yes. It's beneficial to have an expert witness who does not have an advocacy or clinical relationship with the defendant. And bias is definitely a concern, but it's probably the tip of the iceberg. I think that anybody testifying as an expert, your role is to be professional and unbiased and offering your professional opinion. And the court and the decision makers very well may see somebody who has a clinical or advocacy role with that person as unable to be that objective expert. So yes, bias is a problem, but also there's probably a lot of records that the other side could ask for once you put someone's clinician on the stand as an expert witness. And those records aren't, first of all, it's not usually a good thing that those get discovered because they were created in this environment of privilege and of trust. But also there just might be some really harmful things in there. And even if there's not harmful things in the record, a clinician might, if they're answering questions honestly, which they would be, they might have to say some really unflattering things about people that they've worked with. And so there's just way too many downsides to offering expert testimony by people who have worked with the defendant outside of the case itself.
Thanks, Cindine.
Yeah.
Well, in the interest of time, I would just like us to start really wrapping up. And Cindine, I'm just wondering if you have any last comments you want to add or any last statements you want to make?
Just that I mean what I say on this last slide, and if you want to talk further, I'm definitely happy to have that conversation. I'd love to hear about your experiences. I'd love to hear about whether you disagree with me about anything that I've said, and shoot me an email if you want to talk.
Or call. Remember, it's still okay to call people.
I suppose so.
All right, Cindine, that was terrific. You just do such a great job giving us a ton of really important information. And we really do mean what Cindine just said about how interested we are in hearing from you. And so her email's up there, our phone number's up there. Please stay in touch. When you get out of this webinar, that quick little questionnaire should pop up if you don't have time to do it now. In about an hour, I think, or half an hour, I don't remember when we programmed it, you'll get another email from us, and that little questionnaire is in there as well. If you could take really 2 or 3 minutes to fill it out. It also asks suggestions for future webinar topics, so there's an opportunity for you to tell us what you would like us to talk about in the future. So please do that. And again, Cindine, thank you. And thanks to all of you for your attention and your participation today. Thank you.
Thanks.
Have a good afternoon, everyone.
Bye-bye.